Okay. So I call to order the Queen Anne's County Planning Commission for Thursday, August 11th, 2022. And we'll start with the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
He was able to join. He's good. Thanks.
Meeting minutes review.
Madam Chair, I make a motion that the meeting minutes from July 14, 2022 be approved as written.
Second.
Second.
All in favor?
Aye.
Jeff? Mr. Ebersberger? Aye. Okay. So moved. Extension requests, there are none. Updates.
I want to go back to public comment.
Oh, I'm sorry. Missed public comment. Any public comment? You don't have? We're good. Extension request, none. Updates. Amy. Legislation and legal matters.
Good morning, Amy Murdoch, Planning Director. So I do have a few updates for you. There have been two recent filings against the county on a few cases, and I wanted to just to let you know that they have been filed and the actions taken in them. I'll start with Bridgetown Development, which is the mining operation in Ingleside. You last reviewed Phase 3 of that mining operation in January and favorably reviewed it. The Board of Appeals also favorably reviewed that application and granted approval of Phase 3 in March. In the drafting of the decision, there were conditions of that approval, and the applicant's attorney reached out to the county and questioned that the conditions, feeling as though there might have been some errors in the drafting that the board had ultimately signed in July. So staff and I, Steve Johnson and I, looked into the matter. We listened to the meeting and read those conditions very carefully and corroborated that the applicant's attorney was in fact correct. There was a drafting error in the conditions. So the board did address that correction at an open meeting last Wednesday, and corrected the decision. So there is a corrected decision, but in the meantime, with the appeal period looming, the applicant did file an action against the county to appeal that decision. It wasn't an appeal of the board's action, it was an appeal of a drafting mistake. That filing has already been withdrawn, and the updated decision is in the applicant's hands and it's resolved. But if you hear anything about that maneuvering, that's what happened. The next action that has been filed against the county has been filed recently by the Bay City property owners, who initially appealed this board's approval of the preliminary subdivision, which was submitted by Landbridge. The Board of Appeals did uphold the Planning Commission's decision in the preliminary approval of that subdivision. The finding in that case was that it was not an appropriate venue to appeal a preliminary decision, as it wasn't a final actionable item. So that was a good move, just in light of the precedent that could be set if concepts or preliminary approvals are subject to appeal. So that was a good decision. This filing is not relative to that action. The filing that Bay City property owners submitted to court is relative to the ownership of Victoria Drive and Stafford Road, which provide access to the Landbridge subdivision known as Place 6 Place. So what is happening now is Rob Gunter, who staffed that case, is responding to basically a Public Information Act request. We have to provide all of the information in our files relative to the complete history of that property. So I'll update you on that action as it proceeds, but right now we're in response phase for the next 30 days to provide documents. The only other update I have is very preliminary, but the Economic Development Department, through Heather Tonelli, has been working with Stephanie and with me to submit a rural legacy grant to specifically hire a consultant to investigate and come up with some ideas for our agritourism provisions in the code. We attempted to address agritourism relative to alcohol production facilities. It didn't go over really successfully, and we thought that having a consultant investigate and come up with some viable options would be probably the best path forward. There are jurisdictions all over the state who are struggling to draft appropriate regulations as relates to agritourism. So if we get that grant, that'll be a positive planning exercise.
Is that through the state?
Yes, Rural Legacy is through the state, yes.
Okay.
Yeah, I think
Yeah,
it is.
it is.
Yep. I'm just making sure it is a Rural Legacy grant. Is it rural communities, rural?
I think it's
I think it was something Governor Hogan set up.
Yeah, it
this
is through
program.
It is through the
Governor
state.
Hogan.
It's
through the
And
state.
it was through Cecil County, Kent County, and then also Queen Anne's County. And I think each county got like 1.9 million maybe. And obviously it's divided up to multiple projects, but this is just one of them.
It might not be Rural Legacy, it's rural communities. I think I misspoke.
I think the commissioners passed that on Tuesday night.
Yep, yep. That we file, so, yep. Hopefully we'll get, because she put in a whole suite of applications, and we'll see which ones are actually funded. So we'll update you.
Okay.
That's all I have.
All right, thank you. Next, the citizen-sponsored text amendment. Yes, please. Introduce yourselves and
Good morning. I'm Willard Parker from the law firm of Parker Counts in Easton, and I have the pleasure of representing Janet Dean, who's seated behind me. Janet and the Dean family have been here in Queen Anne's County for more than 100 years. It was an active farming family for nearly a century, farming more than 700 acres. Largely land that was on both sides of U.S. Route 301 and Route 304. Janet currently owns approximately 157 acres of land at Carville Road off of 304. And the proximity of her land to 301 and major electric transmission lines and substations has made it an ideal location for the possibility of future solar fields. Her land is squarely within the USSA district. And in the last 5 years, Janet has been approached and actually sold some land to Delmarva Power to expand a substation along 301, and currently is talking to several solar companies with regard to the use of her property for commercial solar power generation. Janet's land, the 157 acres or so that she currently owns along Carville Road, is part of a major subdivision known as Meadow Creek that was approved by the Planning Commission in June of 2006. However, that subdivision has never taken off, so to speak. It's still raw farmland. There were two lots, one 90-some acres, one 60-some acres. Janet retained those, and there were 16 other lots in that subdivision further off of Carville Road. None of the infrastructure has been installed, and the property remains unimproved. Because of...
Wait a minute, do we have that to show on the overheads?
The
I think
act-
as part of the handout
can
that
yeah.
Tony's going to give you, Tony Cooper Smith representing an L Solar is going to give you a handout. Why don't you do that now? Because within that handout are exhibits of the subdivision. There's also sort of a plat showing the property in its relationship to the Carville substation and 301.
I'm sorry to interrupt, Mr. Parker, but as with any text amendment, it does not apply only to one piece of property.
Right.
In fact, there was a case about 3 weeks ago out of, it's a case in Anne Arundel County, though it involved Prince George's County, Court of Special Appeals, I think it was Court of Special Appeals, reported decision, very much on the point of an amendment to a code that was designed to benefit, if that's the right word, one piece of property. It happens to be Lee Airport, not Lee Airport, the airport in Bowie, right on the highway.
There are clearly other properties
Right. So let's
that would
not
be
get focused
subject to
on
the
this
same.
piece of property.
I'm just trying to give you a little background with regard to the applicant, Janet Dean.
Anyway, the point is, in
and
that
her
case,
property.
the Court of Special Appeals said that legislation was void because it was,
This is not targeted to only one property.
Right.
That's not the intent of the text amendment. So Janet originally proposed a change to section 181-38.1B4. Those are the solar array district regulations in your ordinance. And through correspondence and conversations with staff, we have tweaked the proposed text language, and the current proposed text amendment language is found on the handout that you just received from Tony Cooper Smith. It's on the last page of what he's labeled as meeting handout Exhibit 1. And
Which is the third page.
Yeah.
it
It's
is
also on our
the
staff
third
report.
page, I believe, yes.
Yeah, that's on our staff.
That's the same
report.
one that's in the staff.
Yeah.
And actually, I think it's the fourth page, but it's the bold language that would add to subsection 4, which originally read, shall not be permitted on a parcel reconfigured through administrative subdivision for the purpose of adding additional acreage to the area available for utility scale solar arrays. And then the bold language, unless such administrative subdivision includes the abandonment of all cluster lots, sliding scale lots, and large lots within a platted major subdivision, provided that such subdivision is located entirely within the USSA district, and all cluster, sliding scale, and large lots remain in single ownership as at the time of administrative subdivision approval. So that's the intended language. Tony has prepared a bullet point
You
handout.
said it has, you said
Yes,
there are several properties that this would involve in, or?
Well, there are
Potential.
several major subdivisions. This isn't the only subdivision that lies within the USSA district of the county.
Any
And
that would be looking at solar?
that could be reconfigured through an administrative subdivision and therefore could be eligible for solar, provided they met these strict requirements. So we're not the only property.
Okay.
Tony has prepared a bullet point exhibit for you, and I'll ask Tony to sort of review that with you rather than my stealing his work product.
Morning, my name's Tony Cooper Smith. I'm with McAllister, Detar, Showalter, and Walker, 100 Northwest Street, Easton, Maryland. And I'm here on behalf of the solar company. It's Enel North America, and I have Chad Lobley with me. He's a project developer with Enel, and we also have Todd Utz with us. And Todd owns the other part of the land that's within this subdivision that we're talking about. So Ms. Dean owns 2 larger lots that are open space lots, and Mr. Utz owns lots 3 through 18, which are a mixture of cluster lots, sliding scale lots, and large lots. And so Mr. Utz is available as well to answer any questions you might have, as is Mr. Lobley about Enel. So as Mr. Parker said, we have taken a look at the staff report from August the 11th, and going through that staff report, attempted to refine the language that was proposed to address some of the different comments that staff had. So one of the comments that they had related to, we shouldn't just necessarily focus on cluster subdivisions or cluster lots. It should also extend to large lots and sliding scale lots, so that in the event this was abandoned, you wouldn't just be abandoning the cluster lots, but then leaving the other ones. And the whole goal there, which we think absolutely makes sense, is in this scenario is to reduce any potential friction between a residential use and a solar use. And what's being proposed is not a situation where you would have some residential development continuing within the subdivision and some solar. It would be completely abandoning the cluster lots, the sliding scale lots, and the large lots, so that that parcel would be returned to just a single large ag lot. So this handout that I've passed out, I think everybody has a copy. I'd like to just go ahead to Exhibit 2, which again, just to provide a visual. And we understand what Mr. Drummond is saying about not overly emphasizing this particular property, since this language is written broadly, would apply to other properties. This is the only subdivision that Enel is focused on. There could be another solar company that is focused on a different one. But you can see on Exhibit 2.
Excuse me, Mr. Cooper Smith, before
Yes.
we go any deeper, do we know if the 2 commissioners on board on Zoom have access to what we're looking at?
They probably do not, so I will, well, we can get someone to scan and email it to them,
Could
because I
that
think
be
that's
done
the
while we're
quickest,
sort of,
the quickest way.
and sorry guys, just want to make sure you're hearing and seeing what we're looking at.
So should we wait, or should we?
Probably
We can
wait.
wait, yeah.
It'll just be a couple minutes.
Extras in case anybody else who's would like a copy. There may be a couple of extras if anybody else wants a copy.
Would you like us to go to break while we wait?
Yeah, let's go to a break. It's horrible, especially at
Don't have
Little.
a staff report?
just got the information.
Okay. Jeff, did you get yours? Okay. All right.
Thank you. If we could jump to Exhibit 2. This is a map that shows the 2-mile USSA district. The blue star is the Carville substation. The red diamond is this particular Meadow Creek subdivision. So just to give you a sense of where this is located, and again, it would apply just to subdivisions that happen to be completely within the USSA district. So if we flip to the next exhibit, this shows an aerial of the subdivision, of the area. The yellow dots are that's the original parent parcel that contains the entire subdivision. And you can see the outlines on the green agricultural lot of where the lots 3 through 18, where the residential development would have occurred or was planned to have occurred. The brown areas of fields on the north and the south, those are 2 separate lots that are owned by Miss Dean. Those are open space lots that are encumbered with open space restrictions. So the idea here would be to abandon the internal lot lines where you've got, the faint lots 3 through 18 on the green part, so that area and potentially Miss Dean's land too could be used in connection with a utility scale project. Just looking at that surrounding area, Ms. Dean owns the land that is adjacent over by the substation, and she's participating with Anel in this project related to that land that's right around the substation, as well as transmission easements. She also owns land that's adjacent to the south. There's I believe the land is owned by State Highway, and there's a firefighting training area that's buffered by the woodlands over there on the western side. So this just gives you a flavor. And again, I understand Mr. Drummond's point about it's not just focused on this subdivision. We thought it was helpful to have something to look at so that as this proposed language is applied, everybody would see what kind of thing we were talking about. So we're not talking about adding new land on beyond the original parent parcel. We're not talking about aggregating that land with another parcel. It's purely dealing with the internal lot lines within that original parent parcel so that the land can be reused for solar purposes. Exhibit 4, the next one.
Mr. Cooper-Smith, can I
Yes.
stop you there for a second, just for clarification? The overlay that you have with those lot number X through Z or whatever you have there, even though that's green, that's not forested, that's open land, that's cropland in this picture?
Cropland,
Okay.
yes, exactly. And that whole area is actually surrounded. You can see there's forested land that's surrounding that entire area
Right.
of ag land.
That
right?
green is just a different color crop.
Exactly,
It's not
exactly.
forested. Okay, just
Yep.
being clear.
Yep.
Thank you.
The next exhibit, Exhibit 4, shows, this is just one of the sheets from the recorded subdivision. Again, this shows you the original parent parcel, which was approximately 230 acres, and it shows the lots 3 through 18 that would propose to be abandoned if this text amendment were to go through. The next exhibit shows the proposed reconfiguration, which would, we believe, allow the use of that, what used to be lots 3 through 18. It would be newly created Lot 3, and again, all within the existing parent parcel of the original subdivision. So that just gives you a sense of, it's just one example. When we understand that there are approximately 5 or 6 other major subdivisions that are higher density, that are, I'm not sure if they're all in the USSA district or not. We had a conversation with staff at one point, and that was the number that came up that people knew of. So I guess potentially this could apply to those other ones. One distinction, though, is in some cases you could have a subdivision like this where part of it has already been developed. So you could have half of those lots 3 through 18 could have houses on them. This provision that we're proposing, our Exhibit 1 language, would mean that in that scenario, you could not unwind the remaining lots and turn that into solar, which would result in a solar array here and then a residential area right next to it. Not only would the solar company not want to create that kind of friction, but we understand that makes perfect sense. Here you have the provision, or the proposed provision, that talks about how it has to remain in single ownership. So right now the lots 3 through 18 are in the single ownership of Mr. Utz's entity that owns that land, and it would remain so if this proceeded through unwinding that part of the subdivision and then transferring it to Enel. So that would not, obviously you couldn't meet that standard if you had half of it developed with houses, each of which would, presumably be owned by a different person. It would not meet that criteria, and you wouldn't be able to abandon those lot lines. So if we can turn back to the first page of the handout. I can just try to walk through some of these, highlight some of these bullet points, but I'm happy to talk through each one if that would be helpful. But the upshot is that we're looking at trying to clarify that current language that's in 1838.1B4 that purports to restrict the ability to use the administrative subdivision process to, it says, add additional acreage for solar purposes. Our reading of that is that is intended to prevent, for instance, adding new acreage beyond the existing boundaries of the solar district. So you can't use the administrative subdivision process to create a new pipe stem lot that comes into the USSA district. I think staff, they can speak to it, they may have a different view of that, but what we're talking about here is not a scaled aggregation of new parcels. It's just abandoning internal lot lines within an existing subdivision. So what we're proposing is, at least we think, is a narrow exception to the current prohibition on using the administrative subdivision process. So what this does not do, we think, what the amendment would not do is allow this aggregation of land beyond the parent parcel. It has no connection to the last amendment that came through, TACO 2104. We want to be clear about that. This is not connected to that. That dealt with a parcel that was partially in, partially out. This is not intended to allow that parcel to grow in size with a pipe stem. This applies only within the district, and as you can see, the particular property that we've been talking about is right in the middle of it. We think that it's consistent with the comprehensive plan goals, which talk about promoting the environment, environmental protection, also would reduce, septic systems in a large-scale subdivision. It would also help the county implement the policy of focusing solar development within the designated 2-mile district. This would help facilitate that. The staff report, I'll just jump down to the response to the staff report. They identified with the original language certain ambiguities and uncertainties, and we agree with that the original proposed language that's in the application certainly needed to be improved upon. We believe that it has been improved upon, that as you can see in the staff report, and thank you to staff for taking the time to prepare that, the revised language tracks much more closely with defined terms in the ordinance, making it, I believe, much easier to apply and clearer in terms of its effect. I've already talked about how it doesn't have a connection to TACO 2104. And again, we think that this proposal is consistent with the intent of the provision that is designed to avoid aggregating new land. Staff has pointed out that the new comprehensive plan does identify preserving the county's existing housing stock, but when I was reading through that, my sense was the focus there was on really promoting affordable and workforce housing. That seemed to be the main thrust of it. These lots in this subdivision, and Mr. Utz can speak further to that, these are larger lots that would have higher end houses on them as currently configured if it were to be built. Also think in terms of smart growth policy, which in general is geared towards, is reflected in the comprehensive plan and geared towards directing new growth to the existing towns and existing population centers. So by no longer having a subdivision here in this agricultural area, to the extent that there's new development, it'd be happening somewhere else, residential development. So that's our general overview of the proposed amendment. We're certainly happy to answer any questions, and so thank you for the opportunity.
Do you have any questions? Is that the end of your presentation?
It is. I have nothing further to add on behalf of Ms. Dean.
Okay.
I feel like after reviewing the materials prior to the meeting, the first sentence in the staff recommendation, it's based on the ambiguity and uncertainty is exactly how I felt when I read, but now we have this new proposed language, so I feel like we need to get staff to come back to us and let us know your feedback on what we have just seen now, if I could request that.
Yeah, sure you can.
So basically, staff still stands. The intent of this language for the solar language where they're changing, when it was created, was to not allow these tracts to be, or parcels to be merged together to create larger solar projects. They're saying that it's not adding additional acreage. It is because when the language was adopted, it's saying that the solar developers are going to work with the properties that we have within the CS and Ag district where you can have the conditional use within the solar overlay. So it is adding potential additional acreage of solar that could be, developed in the county. So also, you're realizing that those properties obviously were created for single-family dwellings. That was the obviously intent of the subdivision. By obviously dissolving those lots, you're losing potential lots for single-family dwellings. The county can no longer create these major subdivisions due to the septic bill. So right now in the CS and the agricultural districts, you're limited to 7 lots per subdivision. So we can no longer create, obviously, these large-scale subdivisions. So once they're dissolved, they're gone. We're not going to get them back, per se. Also, the housing shortage, we did talk about that, I believe, and there is obviously a housing shortage in the county, whether it is single-family dwellings or obviously there is a high need for workforce housing and affordable housing, but there is still a shorting of housing in the county, depending on whatever type of housing that it may be. So, like I said, when the lots are gone, they're gone. We're not going to get them back unless it's 7-acre lots or 7 lots at a time. So that's basically where staff stands. It's just that the intent of that provision was to not allow these parcels to aggregate together to create a larger solar array. So that's staff's recommendation, still a unfavorable recommendation from staff, even though the language has been tweaked. So
there's purposeful intent behind number 4.
yeah.
I address that comment?
Sure.
So I certainly appreciate staff's view. When we were reading that language, we were trying to understand as well, what was the intent? How does that provision operate? I think we have a slightly different view of it. I think the idea that when this legislation was originally adopted, the policy choice was we are just going to freeze all existing lot lines within this 2-mile district. I don't necessarily see the reasoning behind that, how that would serve the goals of creating a defined 2-mile USSA district where in here, this is where we want you to do these utility scale projects, not out here. So to have an additional restriction that purports to forever in perpetuity freeze lot lines that can never be combined or modified if the intent is for utility scale solar, I'm not sure that the language, to me, when I read through that, bears that sort of policy out. And I'm not sure what interest exactly that policy would serve. This isn't adding new acreage beyond the existing boundaries of the solar array district. It's all within the solar array district. So you're talking about changing lot lines within the district. So that's our thought on that issue, but we understand that staff has their view.
Okay, any other comment? Well, where do we go from here?
Mr. Drummond.
Do you have any guidance, Mr. Drummond?
That's what I was just going to ask the same thing. If any words of wisdom here or clarifications or.
Because I was here when the USSA district was created and the language was crafted, I have to agree with staff's view of what the language means. It's not to say, it's up to you whether you want to change it. Or favorably recommend changing it, I should say.
So do we just take a vote on this as a whole?
I'm sorry?
Or do we just take a vote on the taco as a whole?
That's a new phrase, taco. I don't think, I've never heard that one before.
That's what it says, TACO, taco.
I know, it's
It slashes in the scene.
yeah, I mean, it's, you have to decide whether this is a policy you wish to recommend to the commissioners.
If I may interject, Madam Chairman, I think the question is this broad form prohibition that was outlined in subsection 4, as we look at it sort of in real life, is that still appropriate and necessary?
Probably more so today than it was when it was created.
Well, or is it
Because
better?
we, like you heard, we have a housing problem in our county.
I understand. Or is the prohibition better written with the language that we're suggesting? Does it still carry out the intent of the USSA district regulations? And does it provide a better means for the location of solar arrays within that district? And I think that's the question.
What do you say then to the fact that lots 1 and 2 are under different ownership?
Well, they are now, but that may not be the case when the subdivision, administrative subdivision is unwound.
And also, like,
Conveyancing
Now
to make
we're-
sure it's in single ownership. when
But
you
now we're
submit the
talking
application.
about one lot again, or one property owner. That's not what this was about.
If this goes, you can expect that there'll be a deed from either Ms. Dean to Mr. Utz's LLC, or from Mr. Utz's LLC to Ms. Dean, so there's one owner at the time of the application. That'll be what happens.
I also want to point out, there is open space on this subdivision, so not only are you losing the potential single-family dwelling lots, the open space will go away also. So that's conservation acreage that would be lost.
Yeah, I jump in as well on that. So we are happy to, if it makes sense, to talk further with staff about, are there ways to mitigate the effects of some of these things that staff has pointed out with respect to housing? Are there certain impacts that this is creating, and are there any avenues where there could be, some sort of mitigation of that effect? I don't necessarily know, sitting here right now, whether what exactly that would be. I mean, we can certainly explore that with the open space. It's possible that you could look at retention of a certain amount or something like that. It just seems like maybe there are ways to address whatever the
I believe it would make this board very happy if you could get staff to be on the same line as you were. And if you can talk them into it, then we can probably be talked into it.
Okay.
But right now, I don't think we're in a position to take that chance.
Okay. Would it make sense for us to spend some additional time talking with staff about these issues?
You'd have to ask staff.
Would
This
you
is the
then entertain
tension.
a motion to table it?
Here's the tension this creates. I believe I'm speaking for the staff on this. Not just this text amendment, all the text amendments that come in February. I believe that the staff is uncomfortable with the idea that it becomes a co-author of these text amendments. Am I misspeaking? No. And they believe that it is the proponent's job to present something that would be favorably recommended by the Planning Commission without, I can't think of another verb other than co-opting staff into the process.
Okay.
I don't know if co-opting is the right verb, but that's
Makes
what's
sense.
in my mind.
So if they want it, we can vote on it now and
Or you can ask them to give it further thought in light of the staff's,
come back February. Correct?
Back whenever. Come back whenever.
Can they come back anytime? I thought they could only present in February.
Well, if-
well,
we could debate
they
this all
presented
year.
an amendment, and if you're asking them to think further about it,
Yep.
then they could certainly come back next month. I'm not endorsing the following, I'm just mentioning that the text amendment that allows solar arrays to be outside the USSA, so long as a part of it is in the USSA, does have a provision for the creation of forest, add forest. I've forgotten what the ultimate outcome was. How many
Conservation
acres per,
mitigation.
of forest for every acre outside the USSA. I'm not endorsing that, I'm just saying that was an element of that text amendment.
we can look at that and try to consider what options might exist in light of the comments and the concerns about the impacts on the preserved open space and the impacts on the housing, and there could be some sort of similar mitigation to propose or to think through. And if that's something that we need to do on our own as opposed to in coordination with staff, we can probably look at that, and without necessarily knowing sitting here whether there would be something that would make sense, but we could spend some time looking at that and propose something.
Madam Chair, I'd like to make a motion.
Please.
If discussion is concluded. I'd make a motion that this board send an unfavorable recommendation to the county commissioners based on staff input, council, and the discussion today.
Do I get a second? Jeff, second. Any questions, any more comments? All in favor?
Aye.
Any opposed? One opposed. Okay. Any public comments?
None virtually.
Okay, there being none.
Thanks for coming
Can
in.
I get a motion to adjourn?
So moved. Motion to adjourn.
So moved.
So moved. Hey,
He jumped right to the second.
meeting's adjourned. What you got?
Nothing.